With that, we'll call the first case, People versus Tiffany Reichard? I'm going to ask defense counsel how to pronounce that correctly.
Tiffany.
Where's Tiffany?
Good morning, Your Honors. Michael Faraone on behalf of Tiffany Reichard. I'm always wanting to pronounce it Reichard myself. I may pronounce it that way during this hearing, but I think it is Reichard.
Thank you very much. I apologize for not knowing.
No, not at all. We appreciate being here, and on behalf of Ms. Reichard, thank you for giving us this our time to make this argument. The felony murder rule, properly understood, holds that no person should be allowed to take an innocent life in order to save their own. Ms. Reichard didn't choose to take anyone's life. She did not know that Mr. Beatty was going to take a life, and so therefore, by its own terms, the murder exception to the duress defense doesn't apply. And if it is, if the defense is not allowed to present the duress defense in this case, if they, at the trial, present evidence and convince the trial judge that a reasonable jury could find duress, that will not further the truth-seeking function of the jury or the cause of justice. The narrow rule that we seek, and we did suggest two rules in the brief, but the narrow rule would apply the duress defense to the predicate felony. And if the court were to adopt the narrow rule, the jury would be read the standard jury instruction 7.6. I've looked at it. There's not a letter or grammatical mark in the instruction that would need to be changed. The jury would simply be instructed, if you find the defendant acted under duress when committing the predicate felony, then you can find her not guilty of felony murder. If at that point, the jury would then consider second-degree murder. So under the narrow rule that we suggested, this would have no impact on the law of second-degree murder. We do in the brief talk about the duress defense and how it fits with malice. Of course, we have to do that because going back all the way back to the circuit court, the prosecution has argued that Aaron prevents the relief that we're seeking. And obviously our position is that it doesn't, and so we've talked about that at length, including in the brief before this court, how the duress defense fits the malice element of felony murder, unlike any other. But under the narrow rule, the second-degree murder charge would still be given to the jury. The rule would have no impact on second-degree murder, concern that the prosecution raises in their briefs. It would also, in our opinion, have no impact on the murder exception to the duress defense because by its own terms, the facts of this case, by its own terms, the duress defense does not implicate second-degree murder. And on that, we wanted to also draw the court's attention to Amicus's position that at points they seem to argue that the murder exception to the duress defense was an absolute rule. But in their own briefing, they spend a great amount of time explaining that under pre-Aaron, the duress defense was available. So even in their own briefing, they acknowledged that the murder exception to the duress defense was never an absolute rule. It applied pre-Aaron. Now, the question then becomes, why would it not apply post-Aaron? And my impression is that their argument is that, it applies in other states which are similar to Michigan pre-Aaron. Therefore, it does not apply in Michigan, which is post-Aaron, because now we have the malice element. Well, that's a non sequitur. There's no real explanation as to why the duress defense wouldn't be available. The element in felony murder of the predicate felony is still there. That's what the duress defense would apply to. The predicate felony still has to be proven beyond a reasonable doubt, both pre-Aaron in Michigan, and it still has to be proven in Michigan post-Aaron. That's why we cited in our brief the quote from Justice Scalia. I'd like to have a unanimous opinion and justice from this court. And Justice Scalia in that quote points out that the prosecution is required to prove every element of the offense. Here, they're required to prove the predicate felony of aiding in armed robbery, and for that reason, if defendant was acting under duress when she aided in the armed robbery, the duress defense should be available.
Counsel, would you address Pam's argument about the burden of persuasion, if we agree with your position?
Yes. Our position is that the burden of persuasion should be what is set out in People v. Dupree. In fact, in which this court addressed the burden of persuasion for self-defense. And the court came close to addressing the burden of persuasion for duress, but due to a procedural reason, it never reached that issue. But the same burden of proof should apply. We think it's fair to require the defense to have the initial burden of producing sub-evidence to establish a prima facie case of duress. That's fair. The evidence is, frankly, in this case, and in nearly perhaps every duress defense, the defendant is going to testify, is going to have to testify. So to put the initial burden on the defense is fair. If the defense meets that initial burden, then the burden should shift to the prosecution to prove beyond a reasonable doubt that the duress duress defense is applicable. And in fact, if we look at that standard jury instruction 7.6 in clause 5, it states just that the burden is on the prosecution to rebut the duress defense.
Isn't duress an unusually subjective form of defense, of affirmative defense, such that it might make more sense for the entirety of the burden to be placed on the defendant? The defendant, after all, knows his, or in this case, her mindset presumably better than anyone else does, and shouldn't she bear a fairly substantial burden of proof in this context?
Well, that's not a bad argument, and that has some merit. I mean, and however, it goes too far in shifting the burden to the prosecution. It is their case. They're required to prove the elements of the offense beyond a reasonable doubt. And even if we go back and look at the amicus brief on this subject, it cites, I'll get it wrong, Dixon, in which the United States Supreme Court said that the states can put the burden of proof on the defense to prove an affirmative defense. However, it also goes on to state, the United States Supreme Court, that there's an exception to that. It can't do that if it puts on the defense the burden of disproving an element of the crime. And so that to put the entire burden on the defense and to prove duress comes very close to calling upon the defense to disprove an element of the crime. And actually that full statement of what the United States Supreme Court has said about this subject can be found in a decision from this court, People v. Likine, L-I-K-I-N-E, in a footnote 81, and it sets that out, that there is that qualification for the United States Supreme Court. The court can put the burden on the defense, but not if it requires the defense to disprove an element of the crime. And putting the entire burden on the defense to prove duress would come close to doing that, in our opinion.
Can you develop that? What is the defense, if we were to adopt that rule, what would the defense be required to prove as an element of the underlying crime?
Well, again, I don't want to push the argument too far because, but it would be, you're going all the way back, to the beginning, where the burden of proof is on the prosecution. I think the argument that the burden for the duress defense should be on the defendant has some merit because, it is subjective. She will have to testify. But at the end, and even under the standard jury instruction, which is derived from cases this court has decided in the past, Court of Appeals, in the end, it is the prosecution that should be required to rebut that argument of duress because the burden never leaves them. And I don't want to push this argument too far, but the United States Supreme Court has said that in putting the burden on the defense, we can't ask them to, the courts cannot ask them to disprove an element of the defense. Here we have malice, although, frankly, if the court were to take the narrow rule that we've suggested, there would be an argument that that problem that the Supreme Court has identified wouldn't apply, because under the narrow rule, the duress defense would be presented to the predicate felony only. So the jury and the trial courts never get into this issue of malice and how the duress defense addresses malice. They would simply instruct the jury, if you find that the defendant committed the predicate felony under duress, and find her not guilty. So I would concede that under that narrow rule, that qualification that I've identified from the United States Supreme Court maybe, frankly, doesn't, it's out there, it's something to consider, but isn't really impacted. Also,
Counsel, if this court is not yet persuaded that a defendant here has established duress in any reasonable manner, is it appropriate for us to even inveigh on the issue of duress at this point, or should we wait until after we are persuaded that a duress defense has been asserted and then opine on whether or not it is in fact a defense to felony murder?
well, we would have been happy with that position, but the Court of Appeals got to the case before this court and issued it a published opinion, and under that opinion, the defense is simply not going to receive a jury instruction. It is true, we're here for the court on an interlocutory appeal, so the defense hasn't yet presented its case on duress. That's why when Judge Sawyer from the Court of Appeals had the same opinion, or similar opinion, that he didn't see duress here. The defense hasn't been presented. That will occur at trial, and it's at that point that the trial judge will make the final ruling on whether to allow the instruction. However, even at this point in time, we do see the outline of a duress defense, because the evidence that's in front of the court all derives from police who investigated this case. It's not being presented from defense witnesses. The officers who investigated this case. I apologize.
So what would you have us do in this case? Would you have us opine as to whether duress can in fact supply an affirmative defense to felony murder and then remand it for a further explication?
Yes. An order or opinion from this court saying that, again, the narrow rule, duress could be presented to the predicate felony murder. It would be remanded for a trial, and at the trial, the defense would have to present a duress defense. And they would have to present it under, our position is what we see in Dupree. They have to present some evidence, but it has to be enough evidence that the trial court could conclude that a reasonable jury could find the defendant was under duress. And if the defense fails to do that at this trial, then the duress defense would not be presented, could not, I apologize, the duress instruction could not be given by the court.
But develop it more. If there is enough threshold evidence, then I thought you conceded the burden of proof can be on the defendant in this narrow rule because they wouldn't be required to prove an element of the defense.
Yes, the initial burden, we agree, would be on the defense to present a prima facie case of duress, and the defense, in this case, would not be allowed the duress instruction unless the trial judge concluded that a reasonable jury could find the defendant was acting under duress. So yes, we agree. The initial burden.
But you'd still be putting the burden on the prosecution then to overcome that?
Right, but that's part of the standard jury instruction, clause 5, that if the defense of duress goes to the jury, the burden is on the prosecution to rebut that defense. We're simply asking that the standard jury instruction not be changed. In our opinion, there's no aspect of 7.6 that needs to be adjusted. If the court were to...
Counsel, you do agree, though, that the burden upon the defendant at that juncture would be a greater burden than simply to lay out what you refer to as an outline of a defense?
Yes. Yes. It's at this point that the defense has presented the outline of a defense. At trial, they're going to have to do more than what they've done up to this point. They're going to have to, call witnesses, et cetera. Yeah, so the outline is presented at this point.
So you think the fact that you've laid out what you describe as an outline of a defense is sufficient to have us opine on the legal issue, but you acknowledge that you've not laid out a sufficient affirmative defense yet to satisfy the burden that you're obligated to carry initially?
Well, we haven't presented the full defense at this point, but the Court of Appeals reached the issue. The Court of Appeals overturned the trial court. Yes, we believe there's enough evidence.
Don't we have to wait until the evidence? I mean, this is interlocutory. We don't know what the evidence is yet, right? I mean, what if the evidence all comes in and there's no evidence of duress whatsoever? You would say the defendant has not met her burden of persuasion, right?
Right.
To even get the instruction. Is that right?
We're not asking this court to issue an order saying that
I think I understand. We're just answering the legal question. Right. Does the defense lie if there is evidence to support it?
Yes.
Isn't that all we have to decide today?
Yes.
We don't have to decide if your client is going to be able to present evidence. How do we know?
Exactly. We're not asking the court for an order or opinion saying to the trial judge, you have to give a duress defense in this case. No. the case has to be tried, the defense has to be presented, then the trial judge will make his ruling. We're asking for a holding on whether on the legal issue of whether the duress defense can be allowed in a subset of felony murder cases. That's all we're seeking. And the Court of Appeals has ruled on it, ruled against us, and we're asking the court to overturn that decision and hold it under a limited number of, at least as to non-intentional felony murder, the duress defense may be presented as a legal matter. The case would still be tried in the normal course.
Thank you, counsel. Thank you. Mr. Schrotenboer.
May it please the court, Jerry Schrotenboer, Jackson County Assistant Prosecutor for Plaintiff Appellee. I ask the court to either affirm or deny leave to appeal. There is something of a ripeness concern here. Anyway, 2 points. The first point is there are only 2 ways that this court can reverse. First is to overrule Aaron, which nobody is asking this court to do. Secondly, the second way to reverse is to become the very first case, as far as anybody knows, to say that duress applies to a malice murder charge, whether it's first-degree or second-degree murder. It does not apply to murder unless it is common law felony murder, where the crime is the felony and a death results, where malice is not required. But it does not apply where malice is an express element. Now, defendant's argument about non-intentional murder is really the same thing. He takes the language from non-intentional murder, about non-intentional murder, from common law felony murder cases and applies it here, even though it doesn't apply. And the really big problem is, despite his protestation, that analysis would apply to all non-intentional second-degree murder cases. All non-intentional murder cases, it would apply. He has never distinguished it. On the other hand, defendant's argument that it applies to felony murder but not to second-degree murder leads to an absurd result. The only difference between the two is that we have both are second-degree murder, and felony murder has an extra element. So what he's saying is, oh no, it wouldn't apply to the lesser offense, but it would apply to the higher offense, which of course doesn't make any sense. Now, my second point is, just as defendant admits, in all cases, the prosecution must prove all elements of the offense beyond a reasonable doubt. Malice is an element. In other words, the plaintiff needs to prove in all non-intentional second-degree murders malice. The evidence that defendant is purportedly claiming will come in, all of it. And prosecution, despite that, has to prove beyond a reasonable doubt. I'll waive the rest of the time. Let's use the rest to discuss what this court's concerns are.
Thank you, counsel. I guess I'm having trouble following your absurd result pitch. So I think I agree with you that felony murder is second-degree murder plus something else.
Yes,
and the
Michigan.
Plus something else in Michigan, right?
Yes.
Understood. And the plus something else is a felony.
Yes.
And you don't disagree that if a defendant is charged only with whatever the predicate felony is, that duress is a defense available to the defendant, correct?
You're right. I do not disagree with that. It is. Yes.
So why is it absurd for a jury to say, we find all of the elements of second-degree murder met, but not this one extra element, the felony, because that was, because the prosecution hasn't been able to meet its burden as to that, because the defendant has a defense to that. So why is it absurd for a jury to say, we find all of the elements of second-degree murder and not the extra element of felony murder? What's absurd about that?
What's absurd is not the question that you're asking. There's nothing absurd about that situation.
You?
What's absurd is saying that duress applies to one element only and not to all of it.
Why?
And Well, for one thing, that would confuse the jury horribly.
Well, that's different
In that
than-
situation.
So you've said it's absurd. I'm just asking why it's absurd. If you'd think it's confusing, that might be a different pitch.
It's absurd to say that the less serious crime of second-degree murder, it does not have, but for the more serious crime of felony murder, it does. It is a defense. He's basically, or she is basically saying, oh, it applies to the whole thing of felony murder as long as it's not intentional. Okay. And that felony murder, second-degree murder itself can include non-intentional. So it doesn't make sense that it doesn't apply to the lesser offense, but it applies to the more serious offense. That's the point that I'm making.
Unless you agree with counsel's pitch for the narrower rule, that it applies only to the element that is the predicate felony.
That is correct. Now, that by itself doesn't make particularly much sense. In the first place, we don't need any of this because the prosecution always has to prove it all beyond a reasonable doubt, and it all comes in that way anyways, as the California case that I cited says. Okay, People versus Anderson. The problem there, of course, is, especially since we don't need it for that reason, putting in a duress defense on this element will confuse the jury. We're not talking law professors on the jury. We are talking non-lawyers. And something like that will confuse horribly.
Because jurors can understand defenses when applied to all of the elements but not to one of the elements?
I'm saying they are ever most likely will have a problem with that. And yes, the question of ripeness, yes, we do have a concern in this particular case that we don't know what will happen below. Defendant is asking for, in a sense, a declaratory judgment ahead of time. What we have is, and this is always the problem with an interlocutory appeal from the defense, it's always a problem, that we haven't got a trial yet. We don't know quite what the evidence will be. The jury could acquit. If that's the case, it's moot.
Well, those are all things we consider before we issue an order asking you to come to court to address the question.
That is absolutely correct.
And now you're here.
And now we are here. And you certainly may consider it. What I'm saying is, of course, you granted a MOA. You didn't grant leave, you granted a MOA, which means in the end you could deny leave to appeal, which you did on quite a number of cases last term. And the concerns that were raised are very, very legitimate concerns. I asked the court to either affirm or deny leave to appeal. One or the other.
Mr. Schrotenboer, you were
Yes.
saying, so you're saying that once all the evidence comes in, then we can evaluate if they had submitted. But you're saying, so this all comes in, but she doesn't get an instruction on it.
She gets an instruction of the prosecution has to prove all the elements beyond a reasonable doubt. And if this evidence tends to rebut that, the jury may, of course, find not guilty, especially since, at least at the moment, we don't have any lesser offense instruction. We don't know what that will be. That instruction will happen. This evidence, if presented by defendant, will come in because it's all relevant to her mind state, which is relevant to malice.
You say that instruction will be given. Which instruction will be given? If she's entitled to present the evidence.
Yeah?
But you're saying the jury shouldn't be presented with an instruction that says that it is a defense to the predicate felony.
She will get the beyond a reasonable doubt instruction, which is mandated in absolutely every single case. What I'm saying is defendant basically has her defense that way. The defense is, I did not have the intent, and this is the kind of evidence of the intent. She doesn't get an additional, one, which would really drill into the jury that, oh, this is really important, and at that point, maybe we should just give a directed verdict, because the jury will far more likely just stumble over the stuff. I'm using the analysis that the California Supreme Court used in People versus Anderson, which is
But
in my brief.
If she were just charged with a felony,
Yeah.
she would be given the instruction that the prosecution has to prove every element beyond a reasonable doubt.
That's correct.
But she would also be entitled to the instruction as to duress as a defense to that element. So
That's
why is the beyond a reasonable doubt instruction sufficient if in fact it should apply to the felony?
What I'm saying is that defendant is not out really anything in this case, because she can present all the evidence that she wants, and and the jury will decide it. It works the same way. The California Supreme Court, 6-1, said the same thing. Now, Anderson was not a felony murder case. California has common law felony murder. What happened there is the statute in California said for an offense, duress for an offense, and there was no exception for murder. So the California Supreme Court looked at it and said, yeah, but the common law rule of it doesn't apply to murder still applies, 6-1. And the reason is there's a difference between the two.
Because I'm just trying to
nothing.
understand.
Yes.
I'm just trying to understand the main argument you're making. I just want to make sure I'm getting it correctly.
Okay.
Is the nucleus of your argument that it just that this will create confusion? I'm just trying to understand.
No.
Your overall problem is what?
My overall problem goes back to the original thing. Look, we start with duress. Should duress be a defense? Normally, absolutely. But there is an exception to that, and that's murder. And that's what we have. Because what is felony murder? It is not a felony in the course of a murder. It's not. It's second-degree murder in the course of a felony. And that's what the main argument is. That is exactly what common law courts have been doing for at least a millennium. And this court would then be probably the first court ever to issue a published opinion going against that. That's what the essence of my argument is, especially since defendant doesn't really need it. All the evidence comes in, and the beyond a reasonable doubt instruction comes in anyway. And of course, nothing will prevent defendant in closing from saying duress.
We wouldn't be the only court that has held that, though, correct? I mean, there's a Florida opinion from 2015. Lefebvre suggests that the defense is available to the underlying felony, correct?
Yeah, that
I understand
is-
your position that Aaron is different perhaps than the law in some other states, but we wouldn't be the only one holding that the defense applies to the predicate felony.
In fact, that's the traditional rule. It applies to the predicate felony. And in the common law jurisdictions, it applies. This is all a framing question, right? I mean, if you think of our felony murder rule as requiring more of prosecutors, it's a little weird to say because it requires a higher burden of proof, the defendant loses a defense. It's sort of upside down. This is all a framing question.
No. That's not the way. And the trouble is, I got two questions there. And
Well, you
I'm
agree
sorry.
with, you
Yeah.
already agreed with Justice Kavanaugh, so.
Okay, in the first place, Florida is a common law state. So therefore, it doesn't apply here, very simply because Michigan is not.
But Michigan is common law rule plus an extra element the prosecutor has to prove. And your argument is because we have
No.
an extra element.
No, it is not. Michigan is statutory.
Right.
Common law,
But am I wrong about the
Michigan
elements?
is
The statute says instead of death in the perpetration of a
That's
felony, it says
correct.
murder. So we adopt
Yeah.
all of the elements of murder. So in
Yes.
Michigan, it is more difficult to prove.
Yes.
And the question presented by the Chief Justice is, when it is more difficult to prove, it makes it more difficult on the prosecution, why should the defendant lose an element?
It's
as it
not
relates to
losing an
predicate
element.
felony?
It's not really losing a defense because defendant can always raise the other way around. The point is, why should the defendant? The point is, it switches it over to what has always been considered sacrosanct. You know, when I started this out with Aaron, you know, during the 70s, the prosecutors in this state were just saying you should interpret statutes the way they're written. So in 1980, when this court did precisely that, the prosecutors, of course, were absolutely outraged. However, Aaron was correctly decided. Why? Because that's exactly how it's written. And if it is written that way, unless you want to change the rule of, come to think of it, we will allow duress as a defense to murder, not common law murder.
I understand.
Yeah.
But because of the statutory change,
Yeah.
we would say, by adopting the narrow rule, you do not have a defense of duress to the murder aspect of felony murder. Duress is only applicable to the predicate offense,
So jury can still convict of murder too.
which is the common law rule when it read death in the perpetration of a felony.
Boy, is that ever mental gymnastics. That is very, very difficult to give to a jury, especially when you don't need it.
Is
Extraordinary.
it mental gymnastics to say that,
Sure.
that duress is always a defense to robbery,
Yes.
including when that robbery is a predicate offense to felony murder? What's so gymnastic about that?
To tell the jury that, oh, we have some elements here. Oh, it's a defense to half the elements, but not to the other half of the elements.
Just one element, the felony, just one.
Well, in the first place, I can't imagine any other place where there's something like that. In the second place, that it just is, if you deal with actual juries and actually try cases, juries can get very confused, and that is a
Isn't that why we have instructions to help sort things out for the jury? Seems like a pretty circular argument to say we shouldn't give the argument because it's going to be confusing to the jury. Is that, I mean, is that a
We
recognized,
shouldn't-
is there a case that supports that
We
argument?
should not be giving confusing arguments. There are lots and lots of cases that do not like confusing arguments. Oh, sure, we have plenty of jury
So if the
instructions.
defendant's entitled as a matter of substantive law to a defense, there's a case that says we shouldn't instruct the jury because it'll be too confusing to the jury?
What I'm saying is we should not instruct the jury because it is not a defense to the crime charged. If in fact we also have a lesser included offense of the underlying felony, yes, the jury instruction would go for that one, but not for the higher one. That's where that goes. I'm also relying, of course, on Justice Zara's opinion in the Karp case. Yes, it's unpublished. It uses precisely the analysis that I'm using.
It's your fault. Thank you, counsel. The case will be submitted.